Welcome to IP in a Minute. I'm Richard Gearhart, your host for our presentation today, which will be about non-provisional applications. Non-provisional applications are also sometimes referred to as utility applications. Utility applications are most often the type of application that people think of when they think of a patent application. Utility applications that protect consumer products usually have drawings that are accompanied by the written description of the invention. For chemical or biotech applications, drawings are less frequent, but are often included to show graphs of data that are relevant to the application. Software patent applications also include drawings, but are frequently flow charts or show the software logic. In order to file a patent application as a utility application, certain minimum requirements must be met. A non-provisional utility patent application must include a specification, including a description and a claim or claims, drawings when necessary, an oath or declaration, and the prescribed filing, search, and examination fees. The specification of the patent application usually includes a description of the background and of the prior art. It also includes a summary of the invention, a description of the drawings, and a detailed description of the embodiments. Finally, the application includes one or more claims. The claims create a verbal fence that determine the scope of the protection of your patent. Claims describe the minimum elements that must be present in the invention. Claims are very much legalese and also require interpretation based on legal principles. But to give an example, suppose we were to claim a car. The claim for the car might read, an article of manufacture comprising a body, four wheels, and an engine. These are the minimum elements required for a car, even though it has many more parts, such as a windshield, seats, mirrors, turn signals, etc. In this case, for the car, just focuses on the minimum elements necessary to avoid the prior art. Of course, obtaining a claim this broad would not be possible, but it serves as an illustration of how claims work. Claims include minimum number of elements to define your invention and also to avoid other inventions that have come before. The detailed description of the embodiments describes your invention in detail. Here it is necessary to provide enough information for the skilled artisan to make and use your invention. Inventions disclosed in patents do not typically have to be commercially viable or even work especially well. The standard for this description and the level of detail does not extend to products that have to work in the real world, but they at least have to work somewhat, and the description has to be clear enough to explain how the invention works to someone skilled in the field. Going back to the car analogy, the specification would have to describe the car in enough detail that an ordinary automotive engineer could build it based on the description in the patent application. The introduction of the patent discusses the background and the environment in which the invention was created. So in the case of an automotive application, the application may start with a discussion about how previous transportation methods, including horse-drawn carriages, etc., and how the automobile is improvement on the older technology. The summary of the invention is usually a redrafted version of the first claim. The description of the drawings identifies each figure or drawing in the application and gives a brief discussion of that drawing. So for example, if there are 4 different figures or drawings in the application, the first drawing may be a perspective view, the second may be a side view, and the third and fourth drawings may be top and bottom views. Patent drawings are special drawings and are typically completed by a patent draftsman. The Patent Office has special requirements for the drawings, so it's usually best to use an experienced draftsman to create them. We will talk more in another blog about the requirements and actual filing of the patent application, as well as describing what happens to the patent after it's filed. Thanks for joining us on IP in a Minute. I'm Richard Gearhart, and I hope you found this video useful. Please check out our other videos on intellectual property at the Gearhart Law YouTube channel, where you will find more information description and videos to help you understand the patent and trademark process. Thank you very much and have a great day.